Your Honor.
That's like the last.
Yes, ma'am. Yes, ma'am.
We're ready.
Okay,
We-
bring them up.
We don't see you.
Well, it's because nobody's come up to the podium yet.
Oh, okay.
Here. Oh, let's see.
Oh, maybe now. I got your head cut off. It's always Richard.
All right, Mr. Manning, who are you ready on first?
Judge, we're ready, Miss Bradley, China Bradley.
All right, this is cause number CR 20-1, State versus China Bradley. Are we doing a plea today? Mr.
Yes,
Manning?
Judge.
All right. Miss Bradley, if you will raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, but you're going to have to speak out louder than that, or I'm not going to be able to hear you, okay? Okay?
Okay.
No, you got to be louder than that, or I can't hear you.
Okay.
Thank you. All right, Miss Bradley, you appeared before the court on July 25th of 2023. You pled guilty to possession of a controlled substance, a penalty group 1, a state jail felony. The court considered the evidence, followed a plea agreement that you reached with the state. The court assessed your punishment at the minimum 6 months confinement in the state jail division of TDC and also ordered you to pay a $1,000 fine. The court then suspended that sentence and placed you on community supervision for 2 years. And it was during that period that the state filed a motion to revoke your community supervision in January of 2024. Have you had enough time to speak with your attorney, Mr. Manning, about that motion?
Yes.
Do you understand everything that you read and signed today in your plea agreement?
Yes.
Are you pleased with Mr. Manning and the work he's done for you?
Yes.
And do you have any questions before we go further?
No.
Mr. Manning, do you believe that Ms. Bradley is competent today? And if so, does she waive the formal reading of the state's motion?
Yes, Judge, we do waive the formal reading of the state's motion and she is competent.
Does she intend to plead true on all counts as alleged?
She does, Judge.
Okay. All right, Ms. Bradley, I see that in the state's motion, they have alleged what appears to be 8 separate counts of violations. At this time, how do you plead to those violations? Are those true or not true?
True.
And are you telling me that each one of those is true because in fact it is true?
Yes.
Has anybody threatened, forced, or pressured you to plead true to any of these counts?
No.
All right, the court will accept the pleas of true to each count as alleged. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true?
No, no objection.
All right, then that is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest of closed, Judge.
All right, so Ms. Bradley, I see here that upon that plea of true, the state's recommending that your community supervision be revoked, that you be punished under section 1244A to 6 months confinement in the Van Zandt County Jail, to which you would receive 118 days credit towards your sentence for the time that you've already spent in jail on this cause. Plus, you'd be ordered to pay the balance of your fines, court costs, and reimbursement fees. And that is your understanding of the plea. Is that correct?
Yes.
All right, then based on your plea of true to each of the counts alleged, court hereby finds that you have violated the terms and conditions of your community supervision. The court finds each count to be true. The court follows the plea agreement this day. The court hereby revokes the community supervision of China Bradley. Court assesses her punishment pursuant to the plea agreement at 6 months confinement in the state jail. 6 months confinement in the county jail under section 1244A. Court awards her 118 days credit towards the 180-day sentence. The court also orders her to pay the balance of her fines, court costs, and reimbursement fees. Ms. Bradley, when you are released from the county jail, if you've not paid off all of your fines, costs, and fees, then you need to report to the courthouse and speak with the district clerk's office about setting up some kind of payment plan to get those things paid off so that another warrant doesn't issue. Okay?
Okay.
All right, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over to be fingerprinted.
Next ready on Miss Letitia Hill.
All right, Letitia Hill, cause number CR 18146 and CR 18147. Ms. Hill, if you'll raise your right hand, I'm gonna put you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Thank you. You can lower your hand there. All right, Ms. Hill, you were before the court previously in cause number CR 18146. Sorry, let me get through paperwork. And also cause number CR 18147. You appeared before the court and pled guilty on May 15th of 2018 to abandoning or endangering a child, a state jail felony. The court heard the evidence in each case. The court, however, did not convict you on that day. The court followed a plea agreement, and the court deferred a finding of guilt and placed you on community supervision for a period of 4 years. And it was during that period of 4 years that the state filed its motion to adjudicate and revoke. Have you had sufficient time to review both of these motions with your attorney, Mr. Manning?
Yes, sir.
And are you pleased with Mr. Manning as your lawyer and the work he's done for you?
Yes, sir.
Do you have any questions about any of your plea agreements before we go forward?
No, sir.
And I see that your plea agreements are that upon your plea of true to the allegations, the court's recommending that you be convicted of this offense, that your community supervision be revoked, and that you be sentenced to 9 months confinement in the state jail division of TDC. And I believe that's the same sentence in both cases. And you would also be responsible for your financial obligations that you have left to pay, such as fines, court costs, and fees. And in addition, you would receive 99 days credit towards that sentence for the time that you've already spent in jail on this cause. Is that your understanding of the plea agreements?
Yes, sir.
All right. Mr. Manning, do you believe Ms. Hill to be competent? And if so, does she waive the formal reading of the state's motion in each case? And does she intend to plead true to all counts?
Judge, she is competent. She does intend to plead true to all counts, and we do waive the reading of the state's motion.
All right, thank you. All right, Ms. Hill, then how do you plead to the counts alleged in the state's motions to adjudicate? Are those counts true or not true?
True.
And you're telling me that those are true because you're not just saying that to get a plea agreement. You're telling me that what's alleged is actually what occurred. Is that correct?
Yes.
All right. And Ms. Hill, has anybody threatened you, forced you, or pressured you to plead true to anything?
No, sir.
All right, then court will accept the defendant's pleas of true to each count as alleged. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true in each case?
No objection.
All right, those are admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state,
Nothing further, Your Honor. Thank you.
from the defense?
Question closed, Judge.
All right, then based on the judicial confession of Ms. Hill, the court finds that Ms. Hill has violated all of the terms and conditions of the community supervision as alleged in the state's motion. Court finds those counts to be true. The court this day will follow the plea agreement in each case. The court hereby adjudicates the guilt of Letitia Hill and convicts her of abandoning or endangering a child with criminal negligence in both CR 18147 and CR 18146. The court revokes her community supervision in each case, and the court assesses her sentence at 9 months confinement in the state jail division of TDC in each case and orders her to pay the balance of her financial obligations. And the court awards her 99 days credit towards her sentence for the time that she has spent in jail on each cause. Ms. Hill, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted with a bailiff, If you haven't paid off all of your fines and fees whenever you get out of prison, please make sure you report to the courthouse and set up a payment arrangement to get that handled.
Yes, sir.
All right, good luck to you. Who's next, Mr. Manning?
Judge, I know we're getting up close to the 2 o'clock hour, and I know we have a couple set on Zoom. Do we know if they've appeared yet?
I don't have anyone setting in a Zoom waiting room.
I know Mr. Eaton or Guyton was supposed to be Zooming from Anderson County, and Mr. Phillips from Kaufman.
Yeah, I don't see either one of them yet.
Judge, next word, you got Mr. Dalen Blue.
All right, Mr. Blue, if you'll come forward. This is cause number CR 23-169, State of Texas versus Dalen Lee Blue. And this is a plea on a motion to adjudicate, correct?
That's correct, Judge.
All right, Mr. Blue, sir, if you'll raise your right hand. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you, sir. You can lower your hand. All right, Mr. Blue, you also appeared before the court previously back on September 21st of 2023 to the charge of manufactured delivery of a controlled substance. You pled guilty to that offense. It was a first-degree felony. The court heard the evidence and followed a plea agreement on that day. And the court deferred a finding of guilt and placed you on community supervision for 5 years. And the court also assessed a $1,500 fine. It was during your period of community supervision that the state has filed its amended motion to adjudicate and revoke. And in that, they have alleged what appears to be 9 separate counts. Is that 9? 8? I think that's 9. It goes count 8 and then it goes count 4. So I'm not sure if that's just a misnumbering on the Roman numerals, but there appears to be 9 separate counts. And so have you had enough time to review that with your attorney, Mr. Manning?
Yes, sir.
And are you pleased with Mr. Manning and the work he's done as your attorney?
Yes.
Do you have any questions about your plea agreement?
No, sir.
And I see that your plea agreement is that upon your plea of true to those counts, the agreement and recommendation of the state is that your guilt will be adjudicated, meaning you will be convicted of this offense. Your community supervision will be revoked, and your punishment will be assessed at the minimum 5 years confinement in the Texas Department of Criminal Justice, and you'll be ordered to pay the balance of your financial obligations, with your sentence running concurrent with the Wood County cause. And in addition, you would receive 373 days credit towards your sentence for the time that you've already spent in jail. Is that your understanding, Mr. Blue?
Yes, sir.
Mr. Manning, do you believe Mr. Blue to be competent? And if so, do you believe he understands his rights? And does he waive the formal reading of the state's motion?
Judge, he is competent. We do waive, and he understands his rights and the waivers he's made therein.
All right, Mr. Blue, as to those 9 counts, are those counts true or not true?
True.
And Mr. Blue, has anybody threatened, forced, or pressured you to plead true to any of these counts?
No.
All right, then the court will accept the defendant's plea of true. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection to the state's one.
All right, that's admitted, and the court does take judicial notice of the defendant's judicial confession. Mr. Hartwell, anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further, Mr. Manning?
Rest and close, Judge.
All right, then based on the defendant's pleas of true, the court finds that there is evidence of Mr. Blue violating the terms and conditions of the community supervision. Court finds all 9 counts to be true. The court follows the plea agreement on this date. The court adjudicates the guilt, convicts him of manufacture or delivery of a controlled substance in penalty group 2 or 2A in an amount of greater than or equal to 4 grams, less than 400 grams, a first-degree felony. The court revokes his community supervision, assesses punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay the balance of his financial obligations. Court orders that this sentence run concurrent with Wood County cause number 25,284-2023. And the court awards Mr. Blue 373 days credit towards his sentence for the time that he has spent in jail on this case. Mr. Blue, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over to be fingerprinted. All right, and I do believe that we do have the Kaufman County Jail has just zoomed in. All right, that's going to be Mr. William Howell Phillips III, correct?
That is correct, Judge.
All right, let me see if this is the correct one. All right, good afternoon, Mr. Howell, or I'm sorry, Mr. Phillips. Can you see and hear me okay?
Yes, sir, I can. Thank you.
Excellent. Can you see your attorney, Mr. Manning?
Yes, sir, I can.
All right, excellent. All right, this is cause number CR 24-80, State of Texas versus William Howell Phillips III for pretrial. For the record, Mr. Phillips is appearing via Zoom from the Kaufman County Detention Center. Go ahead, Mr. Manning.
Judge, I have had an opportunity to meet with Mr. Phillips there in Kaufman County. Additionally, we've gone over some of the discovery. We weren't able to go over all of it due to his incarceration there, but we did discuss the main parts of it. We're ready to proceed to docket call, Judge.
All right. Court finding that there are no contested pretrial issues, the court sets Mr. Phillips for docket call on October 3rd. And we'll do it if Mr. Phillips is still in Kaufman County custody, then we'll do it at 2 p.m. If he's in our custody, then we'll just do it regular time at 1:30.
Thank you, Judge.
All right. Thank you, Mr. Phillips, and thank you to the Kaufman County staff for making this Zoom court appearance possible. Thank you.
Thank you as well, Judge.
You're welcome. All right. I don't see Anderson County, so we want to go ahead and move on with someone else.
Yes, Judge, if we want to do the arraignment on Mr. Darian Driscoll.
Darian Christopher Driscoll, CR 24-17. We are set for arraignment. Go ahead, Mr. Manning.
Judge, if we may, I was not able to pull up the indictment here at the jail. I don't know if there's a problem with LGS or my phone. If we could just display that indictment, that would be helpful.
All right, give me just one moment and I'll get that up.
Thank you, Judge. His name is spelled correctly. He understands the charge against him as well as the range of punishment, and he's pleading not guilty at this time.
All right, court enters Mr. Driscoll's plea of not guilty into the record, finds that he waives the formal requirements of arraignment. The court does enter his plea of not guilty into the record and sets this matter for pretrial hearing on October 3rd at 1:30. All right, and I believe our Anderson County inmate is here.
Judge.
Will you need the indictment on Mr. Guyton as well?
Yes, Judge.
All right, good afternoon, Mr. Guyton. Can you see and hear me okay?
Yeah, I'm fine. How are you?
Doing fine. Can you see your attorney, Mr. Manning?
Well, I'll see him.
Okay. All right, give me just a second. I'm going to call your case. Mr. Manning needs to review your indictment. So just give me just one moment, okay?
All right.
Mr. Guyton, can you see the indictment as it's projected on your screen?
Yes.
And is your name spelled correctly at the top and the body of that indictment?
Yes.
Okay. And you understand that you've been charged with a third-degree felony. Third-degree felony carries a range of punishment of 2 years up to 10 years and up to a $10,000 fine. You understand that?
I understand.
Okay. And it's also the allegation of the state that there is a prior conviction out of Fayette County, Texas,
Yes.
that could increase your range of punishment up to a second-degree felony. You understand that as well?
Okay.
You have any questions about the range of punishment in this case?
No.
Okay. Your Honor, at this time, my client pleads not guilty, and we request to be set on a pretrial docket. I'm not sure how the court would like for me to go over the discovery with my client, as he is in Anderson County, and I'm unaware of when he will be leaving there.
Does the state have any information on Mr.
I don't,
Guyton?
Your Honor. However, I can work on trying to find something out and pass that along to the court and Mr. Manning.
All right, Mr. Manning, what I'll do is I'll just set this for pretrial on October 3rd. And if you're unable to meet with Mr. Guyton on discovery, then you'll just bring that up on October 3rd. We'll need to make a decision whether or not there needs to be a bench warrant. Of course, you can request a bench warrant him back over here. We can bench warrant him over here, do the discovery review, and then if Anderson County needs him back or wants him back, we could send him back and forth.
Yes, Judge.
All right, Mr. Guyton, we'll see you on October 3rd, unless there's some other issue. But Mr. Manning will be in contact with you, sir.
All right.
All right, have a good day, sir.
Likewise.
Judge, if we can take up Mr. Randy Sessions' writ.
All right, court calls written number WR 24-39. Randy Sessions versus the state of Texas. Go ahead, Mr. Manning.
Judge, I spoke to Mr. Sessions in light of the information that I was given by the state at the end of court this morning. He does wish to go ahead and go forward with the 17-151 writ and request that the order be signed, granting him a PR bond on that case.
And Your Honor, state's in agreement, on the case that the writ is filed in, state did not hit the 90-day mark.
Okay. All right, then the court will grant the writ. Court finds that Mr. Sessions was not timely indicted pursuant to the law, Article 17-151. Court will set Mr. Sessions' bond in this matter at $25,000 personal bond.
I believe that concludes Mr. Sessions' business. May he be excused?
Yes, he's excused.
Thank you, Judge.
All right, who's next?
Judge, if we want to do Mr. Parks, I believe he's in TDCJ.
All right, court calls cause number CR 22-192, State of Texas versus Joseph Leon Parks. I do show that he's in the holiday unit of TDC. And we have a pending motion to adjudicate or revoke. What do you gentlemen want to do on that case? Do y'all want a bench warrant? Don't want a bench warrant?
Your Honor, if I could have just a moment here.
I'll tell you what, Mr. Hartwell, let's do this. Let's just set Mr. Parks for October 3rd, and then whatever decision the state makes, if it's a request for a bench warrant or dismissal or whatever, then just do that prior to October 3rd.
Yes,
And if it is a bench warrant, make sure we give the jail enough notice that they have sufficient time to make appropriate plans to pick him up.
yes.
Who's next, Mr. Reed?
Judge, next ready on Mr. Jackson.
Jaquavian Antron Jackson, CR 21-361. Go ahead, Mr. Manning.
Judge, I was just recently reappointed on his new case. I'd request to be set out on a status for the motion to revoke.
How long do you think you need, Mr. Manning?
Judge, I don't have my calendar right in front of me. When's our next contested hearing?
2 weeks.
Okay. And the September one?
26th. You want to set him for a status on the 29th, and then if it's not resolved, then contest it on September 26th.
That'd be great, Judge.
All right, court sets Mr. Jackson on August 29th. At 1:30.
Judge, next ready on Mr. Marcus Gibson.
Marcus Lynn Gibson, CR 24-98 and -134.
Judge, I believe we're here on arraignment for 134.
You need to see the indictment.
Yes, Judge, please. Actually, no, I'm sorry. I believe I went over that with Mr. Gibson when we went over discovery. He waives the reading of the indictment. His name is spelled correctly. He understands the charge against him as well as the range of punishment and pleads not guilty to that offense.
All right, the court enters Mr. Gibson's plea of not guilty. And CR 24-134 enters his plea of not guilty into the record. Do you want to go ahead and set this for pretrial and reset the other pretrial?
Judge, actually, I believe we can probably just set both for docket call.
Okay. All right, the court finds that there are no contested pretrial motions requested. Court sets this for docket call, each case October 3rd at 1:30.
Judge, next ready on Mr. Garrett Jocelyn.
Garrett Lee Joslin, CR 24-86 and 169. Do you need the arraignment on 169?
Judge, I was aware that 169 had been filed. That was not on my docket.
Okay. Give me just one moment.
Yes. Judge, my client has been able to take a look at the indictment. His name is spelled correctly. He understands the range of punishment as well as the charge against him and pleads not guilty and requests to be set on the pretrial docket.
All right, court enters Mr. Joslin's plea of not guilty into the record, finds that he's waived the formal requirements of arraignment. Court sets this matter for pretrial along with cause number CR 2486 on October 3rd at 1:30.
Judge, last I have Miss Joyce Wood.
Joyce Marie Wood, CR 24-158. All right, Miss Wood is set for pretrial. Go ahead.
Judge, we have begun the review of Miss Wood's case. However, the records in this are a bit voluminous. I've been unable to complete my review. If I may have additional pretrial on this matter.
Any objection from the state?
No objection, Your Honor.
Is October 3rd sufficient?
Judge, if we have a little bit further than that, I appreciate it.
Got
I think the 17th was given.
yeah, October 17th. You want to do that?
That'd be great.
All right, court sets Miss Wood for additional pretrial October 17th at 1:30.
Good, Ms. Shaw be excused? I mean, sorry, and Ms. Wood be excused?
Yeah, she's excused.
Thank you, Judge. Judge, I believe that concludes my business.
Yes, sir. Thank you, Mr. Manning.
Thank you, Judge.
All right, Mr. Hartwell, we reset. I had a note that we had reset Mr. Robert Driscoll. He was set for plea today. Were you aware of that? I think Mr. Schmidt requested that be reset to August 27th.
Yes, Your Honor, I was aware that we needed a little bit more time to make that happen.
All right, so we're resetting to August 27th at 1:30. And also, Ronald Jack Edwards, you'll recall Mr. Waldron appeared this morning on the morning's docket via Zoom and made an announcement on his client who's in federal custody. I think he said he's been speaking with Ms. Curry about that. The court is setting that for pretrial on October 1st.
Thank you, sir.
All right, I believe that concludes our afternoon docket. Miss Tabraham, am I excused?
Yes, sir.
I am? Okay, thank you. All right, Ms. Tabraham says we're done, so we're done.
Thank you, sir.
Court is going to adjourn for the day. Thank you, Mr. Hartwell.